Hi, I'm Nancy Berna. I thought I would start with a story about my own grandmother and gifting, especially on the topic of meaningful gifts. When I grew up in a family, I would say that my sisters and I were ruffians as compared to my other cousins. My grandmother was a school teacher. She sang in the church choir, and she was a birder. She knew all about birds. She was much more refined than we were. And she had coin collections. And my mom was a working mom, so you can imagine what it was like. She had these three little girls. And what would happen is my mother would go to work during the summer, and we would go through usually her pocketbooks to find whatever loose change she had so we could go down to the candy store or the deli to buy something. After my grandmother died, she must have had these pill bottles with silver quarters in them. And I mean silver. There was no copper in them back in those days. And she had quite a bit of them. And what we did was we promptly that summer cashed them all in at the deli, not realizing the value of the silver coins. I'd hate to think of what they would be worth today. We spent every single one of them. So one of the lessons in gifting to grandchildren is you want it to be meaningful, you want it to last, you want them to understand the value of it. On top of that, there is a layer of gifting, a consideration with respect to being tax-wise gifting. Do you have that list I need? Okay. So the first thing you want to know is that you can gift up to $15,000 per year per person. The problem is this goes off, yeah. $15,000 per year per person, tax-free. Now, for a lot of people, it doesn't matter that much because under New York state law, you can gift $5.85 million tax-free during your lifetime. In addition, you can make any number of gifts during your lifetime, and as long as you survive the gift by 3 years, it doesn't reduce the $5.85 million, right? So if you gift $100,000 and you live more than 3 years, you still can gift $5.85 million. In terms of the federal exemption right now, the exemption is $11.58 million each. Now, if you gift $100,000, then you can gift $100,000 less during your lifetime. So for most people, these numbers are so high in terms of what you can gift that you don't need the $15,000 a year exemption. So a client will say to me, well, what if I give $115,000? Well, in New York State, there's no gift tax. You just have to survive it by 3 years. And for federal, it will come off the $11.58 million that you can gift. So you can see there's really no problem for most people, unless they're multimillionaires. The only thing is you are supposed to file a gift tax return for any gift over $15,000. But I will tell you, a lot of people don't file that gift tax return. But with that being said, typically my clients will gift that money to a 529 plan. That solves the silver dollar problem, right? Because you're not giving the gift outright to the child. Many clients have come in, more so in the last than now, that had uniform gift to minors or uniform transfer to minor accounts. And that's where a parent has given a gift, or grandparent, anyone has given a gift to a minor. The problem with that is the money has to be held in that account, and they get it usually when they're 18 or 21. And in most cases, grandparents or other donors don't want the child to get it during that period of time. And quite frankly, if they're attending college and they are looking for financial aid, that may be the worst time to give it to them. So other than the uniform gift to minors, the other gift could be a gift to a 529 plan. So somebody asked, well, if I live in North Carolina, can I give a gift to my grandchildren in New York? Absolutely. You can gift to their 529 plan. If they live in New York, it will be a New York 529 plan, likely. And you can gift up to $15,000 to each of them. The other question that comes up, who owns the 529 plan. If you own the 529 plan, then the problem is that it is a completed gift for estate tax purposes, but it is not a completed gift for Medicaid. So we had an example where we had grandparents who had gifted year after year to a 529 plan for their grandchildren. And in the summer before, the first grandchild was going off actually to Harvard and needed $50,000 from the plan to pay for his semester at college. The grandfather had a stroke and he needed to go to a nursing home and he had to apply for Medicaid. And the problem is he was the custodian of the 529 plan. So that $150,000 in that plan was considered his asset. Thankfully, he had a wife, because what we did was we changed the ownership of the 529 plan from the husband to the wife, which is an exempt transfer. And it didn't count against him for Medicaid, and we got him on Medicaid. The problem is we could not make the payment of $50,000 to the college. Had we done that, it would have created a period of 4 months that the grandfather would have been ineligible for Medicaid. And 4 months in a nursing home at $16,000 a month was $64,000. So luckily, as I said, we could transfer the $15,000, the whole account to the grandmother. And what we did was after the grandpa got on Medicaid, the grandmother made the distribution to the child and back to the parent who paid it. So it was a little bit iffy. So I always tell my clients, do not become the owner of the 529 plan. One solution is if you have an irrevocable trust, let the irrevocable trust be the owner of the 529 plan. Or if you have 2 children, you can have the aunt or uncle of the other's children be the custodian. And the reason I do that is because I believe if the parent is the custodian, it's going to be counted towards the parent's contribution to the child's education if they're applying for financial aid. But I would say talk to your financial aid advisor. So the 529 is a great way to save money for children. You know, the 529, it grows tax-free as long as it's used for college expenses or school expenses. Speak to your financial advisor. It's a great way to do it, but do not be the owner of that. The other issue is with regard to whether you should give gifts outright or infer the trust. And like I said, I will tell you across the board, most people come to me and they say, you know what, Nancy, estate tax isn't my issue anymore. I'm not really worried about that. What I'm worried about is that most marriages, half of them end in divorce. I don't know what my children or my grandchildren, what their financial status is, if they have creditors, and I want to protect assets for them. And the answer is to leave it in trust. And most of the times we leave it to them in descendants trust. And that's simple, whether you have a will or you have a Medicaid qualifying trust or you have a revocable trust. Typically we have a provision that when both spouses die, the money goes to trust for the benefit of your children. And unless they have a spending or drinking or some spendthrift problem, they can be the trustee of their own trust and still have creditor protection, which means it's protected from the IRS, divorcing spouses, it's protected for Medicaid purposes. It's a great vehicle to give them the ability to protect themselves from others, but it doesn't protect them from themselves. So if you have a child who does have a spending problem, then you may have to name another trustee for that child, right? Or of course, if you have a child or grandchild who has a special need and may need government benefits, you could leave it to them in a special needs trust. And in fact, all our documents have descendants trust with a trigger provision if the beneficiary should later need special government benefits, it would trigger into a special needs trust. So we can protect that. But the problem is that protects it after you die and you leave it to them. What if you want to make lifetime gifts to your children or grandchildren? Typically, you would leave it to them in a trust. The only thing is that in order to use that $15,000 per year annual exemption, if you need that, it has to have what we call a crummy power. And you will see this lots of times in life insurance trusts, right? So the idea of a life insurance trust, or what we call an ILIT, is to create an irrevocable trust, have it own a life insurance policy on your life. And the reason typically is you don't want that life insurance part of your taxable estate. So say you have $1 million policy owned by a trust and the premiums are $45,000 a year. I'm just making this up. I don't even know what the amount would be, depends on your age, but say it was $45,000 a year. If you have 3 beneficiaries, say 3 grandchildren who will be the beneficiaries, then if you give them notice every year that they have 30 or 45 or 60 days to take the premium before it's paid for the insurance, then that's a crummy power. They have a present right to take the money. Then assuming everything goes the way you plan and they don't demand the money from the trust, the money is used to pay the premium, which pays the life insurance. And that way you make tax-free gifts to the trust pays the policy. When you die, the policy is paid to the trust. It divides into the 3 trusts and they have full credit and protection. And it was all done with tax-free money. That's the general idea of an insurance trust. And so that present right is important. But the thing is, what if you say, I'm afraid to give them a crummy right because if I give it to them, they may demand the money. Well, that can only happen once because chances are next year you will not fund the trust, at least not for their benefit. And if you've reserved any rights or have a trust protector, you can actually change beneficiaries of trusts. That's a seminar for another day. But the point is that today, with the exemption so high, it may not even matter. If you can't use a crummy power and you don't want to give them notice, just remember, if it's a New York State gift and you survive the gift by 3 years, it doesn't even count because there's no gift tax, only estate tax, and it's only clawed back into your estate if you die within 3 years. So it may have absolutely no effect under New York State. And presently under federal law, so what if it comes off the 11.58 million? Again, if you're not up there in that type of taxable estate, then it's easy to make that gift and have it count against your lifetime gift of the 11.58, which, by the way, both are adjusted for inflation each year. The other thing is if you create a freestanding trust for a child or grandchild, other people can gift. And I see this lots of times in the case of a special needs child that may have many needs and each family wants to give money to a trust. And listen, if the paternal grandparents and the maternal grandparents each leave a trust, that's 2 trusts for the same child, right? And then the parents may have a trust. It may be simpler for the parents to create a freestanding special needs trust for a disabled child. And then each parent, aunt, uncle, anyone can make gifts to that trust. And therefore, there'll be one trust with all the money for the disabled child. So many times we do that. And then the parents will, or their own trust, would pour into that trust when they died. It's very efficient. It's one trust, and it's very smooth and easy when you're applying for government benefits. Instead of having to account for multiple trusts, there's only one. And we do that often in that case. The other thing is, and this last thing I want to speak to you about, is IRAs, annuities, bank accounts. There seems to be this overwhelming desire for people to avoid probate. And listen, especially after COVID and the court closed down for 3 months, I understand why people may be afraid for probate. I still don't think that avoiding probate should be the only guiding principle in your estate plan. And one of the ways of avoiding probate is naming beneficiaries directly on certain assets. So for instance, you have IRAs. You would name your spouse. You can name your beneficiaries on there. And oftentimes we did name our children or our grandchildren. One of the biggest problems I see with grandparents is they name their minor grandchildren as beneficiaries in the IRA. And it's the worst thing you can do. The reason is because an IRA is a tax deferred, and let's talk about a traditional IRA, but it can happen. The consequences aren't as bad, but you still have the same problem. A minor child cannot collect an IRA. And with an IRA, a traditional IRA, distributions have to be taken by December 31st of the year after you die. And if that child's a minor, they cannot take the distribution. And the penalty for not taking a distribution is the amount of the distribution. So it's a huge penalty if you don't take the distribution. Of course, under the Secure Act, you can take it over 10 years and it doesn't have to be equal. But with that being said, in many cases, what has to happen if you've named a minor, and we had this case where we had an uncle who named 3 nieces and nephews on his IRA, only $300,000. They each got $100,000. We had to go to court and have the parents appointed as guardian. And that was 3 different guardian proceedings for 3 children. And that was done in court and probably cost about $2,500 for each guardianship. It was very expensive and needless. And then once the parents got the IRA, they had to take the distributions and put them in an account at the bank, pay all the tax, and then hand it to them when they were age 18. Now, under the Secure Act, you could probably put off taking the distribution till the child was over 18 if they turned 18 within the 10-year period. But it still can be a problem because you can't change the account. You can't change the investments. You can't manage the account. So in most cases, you will be looking to do a guardianship in order to control that IRA benefit. And it is a disaster. As opposed to, you have a trust of the child, even if it's a trust under your will, if they permit it, or under your trust agreement, or there's a freestanding trust, you merely name the trust for the grandchild as the beneficiary of their share. Simple. When they die, the trustee collects it and exercises whatever rights the child would have. And they don't get the money when they're 18. The trustee can distribute to them over their lifetime as needed. So that problem comes up again and again, where grandchildren are named on IRAs, on annuities, or on bank accounts. And I tell people, you can't do that. Name your children, name an adult on that. And if you're going to leave your grandchild money, do it under a will or under a trust that has a continuing trust for a grandchild. So those are common mistakes that are made. So that's what I have on my list. Grandparent gifting. Does anyone have any questions for me?
We have quite a few questions. First off, I wanted to start, we do have someone with their hand raised. Being that it's a webinar, if you would like to just keep your name anonymous, you can type in your Q&A on the bottom of your screen and we'd be happy to answer your question that you do have. Starting off with the first question here, we have, will there be a seminar on the new community look back period law affects pooled income trust? Can you answer this question after the webinar? We actually had attorney Britt Berner do a webinar on this. It is labeled Medicaid Deadline Fast Approaching, and it is uploaded on our website at bernerlaw.com. So please feel free, Nancy, if you wanted to speak on at all on that, but we do have a full webinar on our website covering that entire topic.
Yeah, I would suggest if you haven't seen that webinar, look at it, make an appointment, see your attorney, whoever it might be. October 1st is coming. And after that, any transfers will create a 2.5-year look back for home care. which we have not had in New York. Right now, you can move your assets in September, and in October, you can get Medicaid, and there will be no look back for community Medicaid. I'm not talking about nursing home Medicaid. If you miss that deadline and in the future you need home care, there will be a 2.5-year look back. So there's a great opportunity now to make those transfers. So if you were thinking about doing a trust, now would be the time to do it.
Great, thank you. Next question, what happens to plan if in parent's name, not grandparent, grantor, and divorce occurs?
Not sure what that question is. Maybe ask it a little bit slower.
Sure. What happens to a plan if in the parent's name and in a divorce occurs?
What happens to a plan in the parent's name? I'm going to have to ask them to ask that question. Maybe they can retype it because I can't imagine what the question is.
Sure. If you have that, if you had typed that question, if you could please go ahead and resubmit that. Next question. Can I give directive to my trustee via my will to gift a friend money out of the trust upon my death?
Okay, so if you want a gift to a friend from your trust at your death, then the direction should be a specific bequest under the trust document that says, I hereby give, devise, and bequeath X amount to this friend. The trustee is only going to follow out the direction that you've given. And usually you do that in the trust document. In addition, if you have a Medicaid qualifying trust, you may have what's called a limited power of appointment. So say you create the trust, you left everything to your children, and 2 years later you say, wait, I want to leave $10,000 to 2 friends in the church. You can exercise that via a limited power of appointment, which is a second document that you do, very short, that basically says, hey, you know that trust I have? I want these specific bequests to be made before you give the distribution to my children. Or if it's a revocable trust, you can just amend the trust to do that. And of course, you can, in a will, if you want, put in a distribution, a specific bequest from the trust, but that sounds kind of silly, because if the revocable trust can be amended or the irrevocable trust can exercise, you can exercise a specific bequest by limited power of appointment, you don't want to rely on doing it in your will, which would then have to be probated and cost money, right? So I would either amend the trust or use your limited power of appointment.
Thank you. Thinking of a value of an LLC interest in real estate, for example, how long does state or federal have to review the value of gift?
It's a 3-year statute of limitations to value the gifts. And typically what you're talking about is making a gift of a minority interest or some interest in an LLC, and you file a gift tax return. And the gift tax return will have with it a valuation report done by a certified evaluator. If you don't give what they call adequate consideration, that adequate disclosure of the gift and valuation, then that 3-year statute of limitation will not run. So when I put together a gifting plan that involves using discounts and valuing LLC interests, I tell my clients, unless you're ready to do a valuation report and spend the money for it and submit it with a gift tax return, don't bother, because it's not going to start the 3-year statute of limitations.
Great, thank you. Can a grandchild be a beneficiary of a Roth IRA without creating a problem?
Well, again, they can be the beneficiary. It depends on, again, who's going to collect it, who's going to manage it, where does the paperwork for the Roth IRA be sent. You can't even change the registration without a guardian being appointed if they're under 18. Of course, if they're over 18, yes, they can be, but you've got the shiny silver dollar quarters, that problem that I told you about. So if they're responsible and they will keep it there, they have 10 years to take the money out of that Roth under the Secure Act. So you could name them.
Perfect. We have a resubmission of that question. It says 529 plan. If I, grandfather, owns it versus I gift to a 529 plan owned by a parent or my grandchild, what happens if the parents get divorced?
Okay, so if the parents get divorced, typically that 529 plan is not part of the divorce settlement because it's the grandchild's money. But of course, the parent is considered the owner for tax purposes and can change the beneficiary. So one of the things, I spoke to a bunch of divorce attorneys and advisors yesterday, that should be brought up and it should be discussed and fully negotiated and provided for in the separation agreement. Who will control the 529 plan and what the terms are. So even though the 529 has its own terms, as between the parents and who's going to manage it, it should be dealt with in the separation agreement. You got to tell your divorce attorney. And it doesn't hurt for your divorce attorney to speak to your estate planning attorney.
Great, thank you. Next question. I have some saving bonds made out jointly to me and each of my 2 grandchildren. Wondering if given them the bonds will count against their assets for college aid or if they would have any other tax ramifications. They are 12 and 14 years old. There are also some for my grown children. Any tax ramifications for them?
Okay, so if you're the owner, then when you cash in that bond or you change the registration on it, it's a taxable event and you will have income for that year. So if you take the case of your grandchildren, you can move the bond to their name. That will be a taxable event for you. Otherwise, you will hold it in your name, and I believe it's they are named as the beneficiaries. So if you die, then they will become the owners of it, and they could wait until after they're 18 to cash it in. It is an asset, and that would be counted if they, they should reveal it on their FAFSA or their college forms. I'm not a financial advisor for college, but I think you have to give full disclosure. So you are the owner until you die. When you die, they become the owner. It would be an asset of theirs. So you have to speak to the college advisor on that, but I think it would be counted as an asset. As to your grown children, again, if you've named them, when you die, they receive it. If you pass it to them and take your name off during your lifetime, this is true for both, you pay the tax. If you die and they're named as beneficiaries, they receive it and then they pay the tax.
Thank you. Next question. If my young grandchildren are secondary co-beneficiaries of my IRA, after my daughter and their father would be their guardian, as indicated in my daughter's will, is it necessary to establish a trust?
You have an IRA, I assume, named your children as the beneficiary, and then you've named these grandchildren as a contingent beneficiary. And when you say young, I'm assuming that you mean that they're under 18, okay? So we have an IRA, you name your children, then you name your grandchildren. Go on with the question.
After my daughter and their father would be their guardian, as indicated in my daughter's will. Is it necessary?
Okay, well, okay.
Go ahead.
So now, if you're talking about your daughter and your son-in-law having a will, then you're assuming that they die and they've named a guardian for their children under their will, okay? So now, if they've done that, the question is that person the guardian of the property and the person? Probably. So your daughter's will is probated, and there's a guardian of the person and the property. Now, you die second, you should probably name the guardian for them, but even if you don't, if they're the beneficiary, then the guardian under their parents' will could collect the asset for them.
Is it necessary to establish a trust?
As long as the parents have a guardian appointed under their will and you agree with who that guardian, and if you have no problem that that guardian could collect it, then you would not need a trust. You could rely upon those papers, right? But you don't know whether, what if your daughter I mean, I'm thinking out loud, which would probably make it like one of those lawyer complicated things, but I'm going to try this anyway. If your daughter or disclaimed the asset, then of course she wouldn't be dead. There'd be no guardian, but chances are she wouldn't disclaim it. So I think if your daughter was deceased, the kids had a guardian of the property. The guardian of the property could certainly collect on that. The only thing, and under the terms of her will, if those are sufficient for you for how the children get the money, then I think that would be fine. I've never had that question before, but as I sit here, if I think of anything else, I'll let you know. So hold on to that email, Liz. But
Okay.
As I sit here, I think that would work.
Okay, thank you. Next question. Does what you have to say about grandparents also apply to aunts?
Yes. Mm-hmm. Thank you today. Great questions. Happy to be here. And if you have any other questions, my email is nberner@bernerlaw.com. I'll be happy to answer them at any time. Enjoy Labor Day. Thanks.